Give me.
All right, this is case number 19-240893. This is Starlene versus Dina. The matter is before the court. Looks like on an application for a subpoena. All right, do I have Starlene Bragg on the Zoom?
I'm Ardina Hendricks. I'm here.
I'm looking for Starlene Bragg. You're on this Zoom, say something at this time. All right, now I'm looking for Ardina Hendrick. Good morning to you.
Good morning, sir.
All right, so you filed a motion. Let's see what's going on here. Just one second. All right, so yeah, this is a petition for an order allowing seizure of property. This is a case in which there is a judgment against you, Ms. Hendricks, in the amount of $5,000, and the plaintiff seems to be attempting to enforce that judgment. It does not appear that the plaintiff is here at this time. Let me try again. Do I have Starlene Bragg?
Judge, she was here. I don't know what happened.
I'm back now.
No.
All right, thank you.
I'm back now. I'm sorry.
Good morning to you,
Good
Ms.
morning.
Bragg.
Good morning.
So you received a judgment in this matter some time ago. I believe that was in small claims court, and that judgment is for $5,000. Correct, ma'am?
Yes, Sharon. It was actually general civil.
All right, very well. And I'm looking here that you tried to get enforcement on that. And what you're asking the court to do is to allow someone outside of this county to enforce your petition for seizure of property. Is that correct?
Yes, Sharon. It was Bay County.
All right. So Miss Hendricks, she wants to collect on the judgment that she has against you. Tell me about that. Why should she be able to do that, ma'am?
Because number one, sir, I'm in the U.S. Bankruptcy court for Chapter 7.
All right. All right. Do you have a petition in bankruptcy?
And she,
court?
yes, I do, sir.
All right. And is a case pending now, or has it already been resolved in bankruptcy court?
It's already been resolved in bankruptcy court, and she is part of it. I filed a Chapter 7.
All right. So is the case, that case is over with?
Yes, sir, it is.
All right. So you have a discharge, is what I'm saying, from bankruptcy court. Is that correct?
No, I don't have that paper yet. No, sir.
All right, so tell me what stage things are. You say you don't have that paper yet. The discharge is everything here. Because obviously if you have a discharge from the bankruptcy court indicating that this debt has been discharged in bankruptcy, that would be the end of this case. But you don't have a discharge. Tell me what stage things are to the best of your knowledge, ma'am.
To the best of my knowledge, I went to see my lawyers on the 3rd of November. It was I had to take in $260 to give to the courts for that judge to reopen the case, and that was done.
All right. Do you have Did you receive any paperwork regarding the reopening of the matter?
I haven't as of yet. No.
All right, very well. Thank you. Just one moment. All right,
But
so,
I'll get in touch with my attorney after I get off the phone, and any papers that he do have, then I'll get them to the court.
all right. So, ma'am, it sounds like I know that there was a petition of bankruptcy that was filed previously, Ms. Bragg, but it sounds like there is a petition to reinstate the petition in bankruptcy. But I would need some proof along those lines. So what I'm going to do is I'm going to continue this matter, set a new date 2 weeks hence, and Miss Hendricks will have to. She or her attorney will have to present some paperwork establishing that there is a petition in bankruptcy that is proceeding. Otherwise, the court would be inclined to grant your relief for enforcement on the judgment. The bankruptcy would stop everything, and if there is something that is pending in bankruptcy or likely to go forward, then that would stop this case. So I'm going to send it over 2 weeks, and then I'll take a look to see whether or not there is in fact a petition that's going forward in bankruptcy court. And if that is the case, then that will stop this case. If that is not the case, then the court will be inclined to grant your petition for enforcement on the judgment. So the next action date.
I'm sorry.
What do you want to say, ma'am?
I apologize. What I wanted to say is, Ms. Hendricks, she did file Chapter 13, in which she was released from bankruptcy for whatever reasons they dropped her. She also filed Chapter 7. That happened again because I received a paper in the mail. I won't have a problem with sending it over, that she is no longer in bankruptcy. So every time we come to court, it's always this thing about, I filed bankruptcy.
Let me stop you there. Let me stop you now.
Okay.
I don't care about all that. How many times you been in front? How many times you been in front of me?
I believe 3 times, 2 or 3.
No, that's not true. This is the first time that this case has come up in front of me. You've had this in front of other people. You filed a petition, and I set this up as a hearing. This was in front of another judge. As I indicated to you, you may have, and she may have, a significant history on this case. Anytime the issue of bankruptcy comes up, bankruptcy ties my hands, your hands, her hands, everybody's hands. And whatever the history is of all of that, not of any particular concern to me. What is of concern to me is if there is not something that's going forward in this case, we'll know that in 2 weeks. And if there's not something going forward in this case, I can't make up for 2 years or whatever you may have dealt with. But if it takes 2 weeks to find out if there's something going on in bankruptcy, that's what I'm going to do. I'm going to take those
I understand.
all that other stuff. I guess maybe it's
no, I
understand.
I understand. I was just trying to.
Nothing. I see in the file. I read the diary already that there was a petition that was dismissed at some point. I know that petitions can be reinstated. The lady has indicated that she's got something that's reopened in bankruptcy court. I'll find that out in the next 14 days. If there's nothing in bankruptcy, then you have the right to enforce your judgment. That's what my determination is today. So we got to find that bankruptcy issue out, and I'll know that by the time this case comes back in front of me. So I'm setting the matter over for, we're going to set it on the 29th of November. November 29th, that's going to be at 9:30 a.m. The matter is adjourned for the reasons that I've specified on this record, and then I'll address the motion for enforcement at that time. All right, good day to the two of you. Come back into the same Zoom address that you came into today on 2 weeks from now, the 29th at 9:30 a.m. and then we'll address this issue at that time. All right, good day to the two of you.
Thank you, Honor.
Thank you.
All right, the court calls case number 22-191-441. This is Portfolio Recovery Associates LLC versus Lisa Sims. The matter is before the court for a hearing, but I see that there is a consent that was entered previously regarding this matter. Your appearance for Portfolio, please. Do I have Lisa Sims? All right, we'll pass on that matter. The court now calls case number 2151346. This is Michigan Basic Property versus Daryl Anthony Henry. The matter is before the court on an application for a subpoena, on a subpoena to appear. No appearance at this time for the plaintiff.
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Thank you, counsel. Good morning to you. Daryl Anthony Henry, or counsel for Mr. Henry, if you're on the Zoom, please say something at this time.
Yes, I am, Your Honor.
All right, good morning to you, Mr. Henry. This matter involves a subpoena wherein the plaintiff seeks to enforce a judgment that was entered and are seeking information towards that end. Have you had an opportunity, Mr. Cox, to speak with Mr. Henry regarding this matter, sir?
No, I'd actually like to be placed in a breakout room with him and conduct the discovery subpoena.
That's exactly the route that we're going to take. Mr. Henry, I'm going to send you to a breakout room to speak with the attorney on the other side of this regarding the subpoena that you have appeared on and to discuss the issues related to that subpoena. So I'm sending you a notice to go to breakout room number 1, sir. And that notice is coming to you right away. Just click right in. And when you're done, you can come back into the courtroom. All right. Good day to both, to the two of you. Mr. Cox, you got the notice, sir?
Got it. Yep. Thank you, Judge.
All right. All right, this is case number 22191011. This is Anesthesia Services Affiliates versus City of Detroit. The matter is set before the court for a hearing. I don't know if this is the first hearing in this regard, but your appearance for the plaintiff in this matter, please. For Anesthesia Service Associates, your appearance at this time. All right, for the City of Detroit, your appearance at this time, please.
Good morning, Your Honor. Alfred Ashew, P82536, on behalf of defendant City of Detroit.
All right, thank you, Mr. Ashew. Anybody here for Anesthesia Services Affiliates? Counsel, have you spoken with anybody from the plaintiff's office today?
No, I have not, Your Honor. But I will state from my record, it doesn't appear that we received a scheduling order opening up discovery in this matter. I just found out about the hearing just by checking the docket today. So it's possible that they didn't know about it.
Yeah, that's my practice is to set this initial hearing up as a status conference and a scheduling conference. So have you had some contact in regard to this with the lawyer on the other side, or any dealings at all?
No, not other than providing an answer, nothing yet.
Gotcha. All right, so your inclination is that you would like to go ahead and set a schedule on this matter and the next hearing. Is that correct, Counsel?
Yes, just so that we can conduct discovery.
Thank you, Counsel. I will grant discovery in this matter, and for a 60-day period of discovery be granted. At this time, I'm going to set this matter over for its next action date. That date is going to be January 10, 1/10/23. And that date will be a pretrial conference date and also a motion hearing date, should there be any motion that either side might wish to file. The rules regarding filing motions will be set forth in paragraph number 6. They will allow for streamline of filing motions so long as the other party has at least 10 days to respond to any motion. I will hear it on the date of the pretrial conference. Again, that date is 1/10/23, and that's going to be at 9:30 a.m. 1/10/23 at 9:30 a.m. And I will generate a scheduling order on today's date. You'll get it in the mail in the next few days. Thank you.
Thank you, Your Honor.
Counsel.
Thank you.
The court calls case number 22191381. This is Portfolio Recovery Associates LLC versus Nicole Cruz. The matter is before the court. Let's get some appearances on appearances for Portfolio, please. Any appearance with Nicole Cruz? We'll come back to that matter. The court now calls 22186328 Beaumont Health versus Christine Abel. The matter is before the court, set on for a hearing. This is a status conference scheduling conference here. Your appearance for Beaumont, please.
Thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
Thank you, counsel. Good morning to you, sir. For defendant Kristen Abel, if you're on the Zoom, say something at this time.
Yep, I'm here.
All right. Good morning to you. Looks like there was an application for entry of a default in this matter.
Your Honor, if I could give you a status that will make it quicker for you. Ms. Abel resolved and paid this in full resolution yesterday. We did fax the court a dismissal, thinking though that it may not get there. So we are both here. If you would give me a day or two, I will email that also to your court if you'd like me to.
All right, that makes sense to you, Ms. Abel?
Yes, it does.
All right, very well. I'll receive the order resolving this matter based upon the representation set forth on this record. And Mr. Burke, if you would send that to the following email address. That's Carmen.Banks, that first name CARMEN, Carmen.Banks @36districtcourt.org.
I will do that. Thank you.
All right, we'll get that taken care of right away.
Thank you, Your Honor. Thank you.
Thank you.
Thank you. Good day to go.
Have a great day.
The court now calls case number 22181876. This is Crystal Dunlap versus University of Detroit Mercy et al. The matter is before the court, set on for a looks like a motion here regarding this matter. All right, your appearance for plaintiff in this matter.
Plaintiff here.
All right, do I have, all right, I see I have Ms. Dunlap. Ms. Dunlap, you're not represented by counsel, is that correct, ma'am?
Right.
All right, ma'am. All right, and for University of Detroit Mercy, counsel regarding this matter, please.
Good morning, Your Honor. Stephen Lynch, P70211. I'm appearing for Detroit Mercy.
All right, thank you, counsel. Good morning to you as well. All right, I see that I sent this over for a hearing on your motion for summary disposition in this regard. Ma'am, I remember this case came up before. I think there was something about you had not received some paperwork. Is that correct, Ms. Dunlap?
Yes, that at the last hearing, you had ordered Nabbit not to sell the loan, but they sold the loan September the 8th.
I could hardly hear you then. Say that again, ma'am.
I said at the last hearing, August 17th, you ordered Nabbit not to sell the loan, and they sold the loan September the 8th.
No, I didn't
So
order
now
them
I
not to sell. I didn't order them not to sell the loan. No, I didn't do that. All right.
Well,
Let me see.
anyway,
I'm sorry, ma'am. Go ahead, Ms. Dunlap. I'm listening to you.
they sold the loan, so now I have to get my records from and guarantee agencies.
I don't know what's going on with your device. Maybe you're too close to it. Maybe you don't have it up loud enough because it's very clouded as you communicate. When you start talking to me, I can hear you some, and then it gets worse as you talk.
Your Honor, while Ms. Dunlap's question,
Hear me now?
1 second, counsel.
Hello?
All right, yeah, Ms. Dunlap, okay, say something now. Let me see if I can hear you any better.
Yeah, can you hear me now?
Yeah, that's
Is it better?
that's a little. Okay, got you. All right, stand down for just a moment. Let me hear. There's counsel for Nabian, I believe. Your appearance, please.
Yes, Your Honor. Good morning. Thank you. Mami Kato on behalf of Nebian entities, the co-defendants, P number 74237, Your Honor.
All right, thank you, counsel. Good morning to you. You had something you wanted to weigh in on, please.
Yes, and we also filed a motion to dismiss under C8 at around the same time as University of Detroit Mercy, and that should also be pending before you, Your Honor. And if not, we can certainly renotice it for a different date.
All right, got it.
And I also filed a motion too.
And your motion was for a more definite statement, correct?
No, Your Honor. At this point, we are seeking
No,
dismissal.
I'm talking about Ms. Dunlap. Ms.
Oh,
Dunlap,
I'm sorry, Your Honor.
your motion was for a more definite
Yes,
statement.
I filed one for a more definite statement, and then I also filed a motion because David had sold the loan, and when they first presented the documents to the court, they were supposed to send in it's called the electronic record for e-signature, because at the last hearing, you had asked me, did I sign the document? And I said, no.
All right. All right, so Mr. Lynch, let's.
And they don't have a.
All right, so you're saying that the challenge here is that you never took out any loans with U of D or never made any loans that would that involve your schooling there, correct?
No, what I'm saying is Navy consolidated the loan, and when they consolidated the loan, they said the loans are in the they were Sally Mae loans, and I never had a loan. I never consolidated the loan.
Yeah.
And
So is that your issue? Is that you have a problem with the fact that the loans were consolidated?
I never had a loan with Sally Mae. And also I never consolidated. I didn't receive a consolidation promissory note to 2020 when I had to go to the Consumer Protection Bureau and receive it. I never consent for a consolidation loan. And when I look on the National Student Data System, it says that it was consolidated with the school of University of Detroit Mercy.
All right, let me hear from Mr. Lynch. Go ahead, sir.
Thank you, Your Honor. Yes, last time we were here was a pretrial and my motion for a more definite statement on the original complaint that the plaintiff filed. Since that time, she did file an amended complaint and also filed several other things with our office, such as the aforementioned motion for more definite statement of my answer on a document entitled Discovery, then a document titled 7-day notice to answer the complaint, which I find weird because she filed a motion for a more definite statement. And then 3 days later, after that, she filed a default against my client, UDM. I not only filed an answer to the amended complaint, I also filed the C8 motion that's before the court today. As you could just look at the amended complaint, Detroit Mercy is mentioned only a handful of times, and there's no discernible causes of action filed against Detroit Mercy. While the pleadings state that plaintiff brings this allegation against the University of Detroit Mercy for a debt collection, there are no factual allegations made against the defendant regarding any debt being owed, and there are no actual causes of action that she pleads. There's 3 itemized counts in her amended complaint. One is called assignment, chain and title breach, doesn't mention Detroit Mercy at all, and there's no allegations against Detroit Mercy. The second count is attribution, authenticated audit trail. Again, no mention of Detroit Mercy and no allegations against Detroit Mercy. And then the third count is just titled debt. None of these things are actually recognized causes of action in the state of Michigan or any other state that I can find, or federal law that I can find. So we filed a C8 motion, which can be granted only where the claims alleged are so clearly unenforceable as a matter of law that no factual development could possibly justify recovery. And a mere statement of conclusions unsupported by any factual allegations are not sufficient to state a cause of action. That's black letter Michigan law, Your Honor. And this amended complaint fits that to a T. She's already had a chance to amend it. There's just no allegations against Detroit Mercy. They did nothing wrong, and there's no causes of action that she's filed against them. So I'd ask that the amended complaint be dismissed and Detroit Mercy be dismissed from this action with prejudice.
Thank you. Thank
Can
you,
I
Counsel.
respond? I said, can I respond?
Yeah, go ahead, ma'am.
Okay, when they filed that complaint, both of them merged together, and they together on the complaint. And one side denied, and then Michigan court law rules that if it's not denied, then it's admitted. So then NAVIT admitted a lot of things in the docket because they didn't deny anything.
All right, ma'am.
Because see here, they filed the amendment complaint together, and one side is denying and one side is admitting because NAVIT didn't deny. So if it's not denied, then it's admitted. So then which one can you believe? That's why I sent the letter out for them to respond to the complaint separately. And then they told me no. I have an opportunity to talk to Attorney Cato twice. And I talked to her and I asked her, why did she say that DETCA ELT NAVIT trust is on the loan when that's just a nickname for NAVIT? It has nothing to do with Deutsche Bank. And in the state of Michigan, Department of Education canceled NAVIT servicing license. And in the state of Michigan, the Attorney General wrote that NAVIT cannot service a federal loan unless it's up under a federal lender. And I called Deutsche Bank, and Deutsche Bank said they're not in the student loan industry. They're into the real estate business. They told me NAVIT had an account with them, and that's the nickname to their account. And when they sold the loan to Michigan Guarantee Agency, I called them, and they're represented by the Educational Credit Management Corporation. And I asked them, did they pay Deutsche Bank? And they say no. They say they paid NAVIT, the servicer.
All right. All right. Thank you, ma'am. Thank you very much. Thank you, Ms. Donlin. Ms. Cato, what do you have to say in this regard? I know that you filed a motion in this regard as well.
I do, Your Honor.
Your motion is a motion for summary disposition, a C8 motion as well.
Yes, our base is exactly the same as Mr. Lynch's. If you look at the amended complaint, and certainly, Your Honor, you granted our motion for more definite statement, gave the plaintiff more opportunity to spell out her claims. And as it stands, you look through the amended complaint, and there's really, we can't make head and tail out of it. But more importantly, to the extent, as Mr. Lynch referred to, her causes of action are non-existent, and court rules are clear. The court has, there is no claim in the state of Michigan where there is no recognizable causes of action. And the three claims that Mr. Lynch read into the record, the assignment, chain, and title breach, which is count 1, attribution, authenticated, audit trail, count 2, debt, count 3, and there's also an unnumbered title called concealment. Again, none of these are cognizable causes of action. As such, the amended complaint fails to state a claim, and I think that warrants a dismissal against all defendants, including all the Navient entities, with prejudice, and that's the relief we are seeking, Your Honor.
Yes, but in the mimic complaint, the Navient admitted because they didn't deny. And also I had asked them, I said, I didn't sign for a consolidation loan. I didn't have any loans with Sally Mae. And at the time, Attorney Cato presented her case. Department of Education, who rules the promissory note, says that at the time they presented the case, they have to have the East Side record that I signed the complaint, because on the application, the promissory note, Navient tapped the word web on there. They put my social security number on there. They put an account number on there called start with a 655 on it. And the Department of Education ruled that for a typed signature, they have to put a combination of A, B, C, or D by the type name. And then they said that you have to have the record of retention. You have to go in there and be able to see your consent form, consent for electronic signatures. And then it say you got to have all these documents supposed to come. I have never received any document from Navient for consent for electronic signatures. I haven't seen any application that I signed my name in. And I had asked Attorney Cato, I said, how did my ID get on this document? She said she didn't know how. And I asked her, I said, you're supposed to have they call this electronic record for each signature. And the Department of Education said that if they don't have that record, then it's not admissible in court. And I didn't receive anything from Navient. And then they typed a Saul Bradfield. I don't know a Saul Bradfield. They put a P.O. box. When the P.O. box is it's not it doesn't belong to me. And the application said no P.O. box used for a fifth no Evelyn Megtox. And then the Department of Education said you cannot alter the document after it's signed. And I didn't benefit for no consolidation because my lender was Chase Sally Mae, Chase Manhattan Bank. And then they had sold my loans to an entity called Chase Sally Mae Education Loan Trust. And that entity owned by Chase Manhattan Bank. So Navient haven't sent me anything that East Side record. And this is what I'm looking from them. And she told me and when I talked to her, she was bringing it to court.
All right, I think I've heard enough. Thank you, Ms. Dunlap, Ms. Gato. Thank you, Mr. Lynch. I've listened to the presentation arguments with respect to the various motions for summary disposition in this matter. Motions for summary disposition in general test the at the outset of matters, test the integrity of the complaint and the allegations that are brought before the court. And one of the principal issues raised oftentimes in the challenge with regarding to a motion for summary disposition is whether or not the complaint sets forth a cause of action upon which the court could grant relief. And the amended complaint, as I looked through the amended complaint, the language set forth, the allegations set forth, do not give rise to a cause of action upon which the court could grant relief. I've heard Ms. Dunlap set forth a number of conversations that she had with various entities along the way. that various banks have told her certain things, and that the education department agents have told her certain things. She may, in fact, have some administrative process that she has the right to go through and exhaust administrative remedies. Also, she claims that some of the federal connections to any loans that may have been made, that there are some nuances in that regard, which may give rise to a consideration of some federal laws, and which would mean that it would not be jurisdictional to this court. But the key thing is that on balance, when I look at the four corners of the complaint and the amended complaint in this matter, even if taking the statements made in the complaint to favor Ms. Dunlap, they do not give rise to a cause of action upon which the court could grant relief. There is nothing about this complaint that would give rise to the court taking action that is provided to this court by way of statute that would allow this court then to enter some kind of order allowing some type of relief. Excuse me, don't interrupt, ma'am. To allow for some type of relief, because there's not a cause of action. There's not a cause of action upon which the court could grant relief. And accordingly, because that is the case, then the complaint in this matter, together with its various counts, will be dismissed where there is no cause of action. Motion for summary disposition is granted accordingly, and I will sign an order consistent with the same. All right. Good day to all in this matter.
Can I appeal this? Can I appeal it?
No, you may not, ma'am. Thank you. Good day to you.
Thank you, Judge. Do you want us to send that to Carmen Banks?
That's correct.
Okay, I'll get that out today. Thank you, Judge.
Thank you, Your Honor.
Mr. Jarrett, I've been looking through here for what should come up, because I know that you're here for something, and I see Mr. Harris is here. Tell me which matter you are on.
Judge, I am here on behalf of Paul Curtis, who has previously been representing himself. I had prepared an appearance, and
I see the case number now. For some reason, I don't have the file, so thank you, Counselor. I know which case you're referring to now. Just one moment. Let me see what's going on here. Just 1 second here.
If I may, Your Honor.
Yeah, I'm going to go on the record on it, and then we can go.
Okay, very good.
So I don't have a file, but I do have a register of action. So this is case number 22-181872. This is Paul Daniel Curtis versus Larry Davenport. Looks like the matter is before the court. I know there was an intent to dismiss at some previous point, but let me get your appearance on the record for plaintiff in this matter. You may at this time.
Judge, my name is Ernest Jarrett, and I'm here on behalf of Paul Curtis. And I'd like to comment, if I could, further about our attempts to file something. But, you know, I can do that after Mr. Harris has had a chance to speak.
And give us your P number, Mr. Jarrett, and then I'll go to Mr. Harris, and we'll come back to you, sir.
Must I, Judge? Whenever I give my P number, people say they didn't know that there was, you know, color back in those days. But my number is P.
That start with 1.
Yes, exactly. My P number is P29770.
Yeah, well, mine getting old too, but it's 39, so it's a little bit later than that. That's back there. All right, Mr. Harris, your appearance, if you will, at this time, sir.
Good morning, Your Honor. May it please the court. Brian Harris appearing on behalf of the defendant, Larry Davenport, P66105.
All right, thank you, Mr. Harris, and good morning to you. Mr. Jarrett, go right ahead, sir.
Okay, this is more housekeeping than substance, but I think it's important to bring it to the court's attention. First of all, as I said, I'm here on behalf of Paul Curtis. I have prepared an appearance, And I also, I've had a chance to speak with Mr. Harris a couple of times. And because I was scheduled for trial in Oakland County Circuit this morning, he and I had agreed to ask for an adjournment of this matter. However, my Oakland County matter, although we didn't start a trial, I did have to appear out there by Zoom earlier today. And that trial is not going to go until after the new year, and therefore I'm here today. We had attempted to file, or I had prepared an appearance and the stipulation, which is, I guess, moot at this point. But my secretary indicated that she would have to physically file the appearance with the court, taking it over to the court, because we thought that there was electronic filing with 36th District Court, but we couldn't confirm that. And then towards the end of last week, my secretary had a personal emergency and wasn't able to file it. So if the court will take my oral appearance today, I'll be sure to get a written appearance into the file in short order.
And Mr. Jarrett, on that point, I will accept your appearance. And as it relates to the written document, the email address that I provided, it can be the written appearance can be sent via that email address. And that's Carmen, first name is Carmen, CARMEN .Banks is the last name. And that's at 36th District Court, 36th, 36districtcourt.org. And if somebody will email that over, then that will suffice the filing of the appearance.
36th district is spelled out?
Yes, sir. 36th District Court. District Court is spelled out.
Okay.
.org.
Okay. Thank you very much, Judge. If I could go a little bit further before you proceed.
It sounds like it. Oh, well, go ahead. I know that there was initially a request for adjournment, but maybe there's some other traction. So go ahead, Mr. Jarrett, and I'll come to you, Mr. Harris.
Okay, I spoke with Mr. Harris, and he and I think, have a similar problem. I spoke with Mr. Curtis, who was representing himself, and he indicated that he did not receive any notice of today's conference. And I only am aware of the conference because Mr. Harris told me about it during one of our conversations. And I'll let him speak for himself, but I understand that he also had some difficulty receiving notice from the court. Now, there was an underlying action from which this particular case arises. And I believe that the court is noticing Mr. Frank Jackson as one of the attorneys in this case, and he is not an attorney in this case. He was an attorney in the underlying action from which this case arises. And I don't know who else the court served, but I know Mr. Curtis wasn't served. I believe Mr. Harris can confirm that he wasn't served. So whatever we need to do in order to make certain that the court is communicating with us and not some other set of lawyers, we'd like to do it.
All right, so I have Mr. Meissner, Robert Meissner was served or received the notice, and Mr. Frank Jackson. Those would have been the two persons that would have gotten notice. So what I was suggesting in regard, obviously, when you send the appearance, and that'll cover it, but if today, once we're done, if you could chat the numbers where notices should be sent, I'll make sure that the file is documented so that whenever a notice is sent out, it will be sent to Mr. Jarrett and Mr. Harris. If you could chat that to me, or if either one of you will choose to fax or strike that email over something with your address on, I'll notate the file so that we won't have this problem again in regard to any notices going.
Your Honor, if I may.
Yes, sir.
I'm with Robert Meissner's office. I'm an associate of his, but we did not receive a notice in the mail. My secretary actually had to get it via email from the court. I'm not sure who she spoke with, but it took several weeks in communications with several court staff employees to get the notice sent over, which I provided to Mr. Jarrett.
That's all. You're on Telegraph Row, Suite 467?
That's correct, Your Honor. And if I may, if we did file an answer in affirmative defenses, and I hope they're part of this action and not incorrectly logged in the underlying proceedings, because there does appear to be some confusion in that regard.
Yeah, this is all I have. If you can, that's all I have. Inject with a register of action, and that's it. So that concerns me because this is a 22 file, and so there's not an issue of it being, you know, in the file room way back in the corner somewhere. So this should be. So I'll track it and find out where this particular file is, and I'll make sure that the notices go out to Mr. Meisner's office, and I'll make sure that the notice goes out to Mr. Jarrett's office as well. So I'm going to track it. Maybe the fact that there was another case, another file, may be a part of the issue here, because again, I didn't even get a file up, and so any answer, I don't have a complaint or anything in front of me today. And that's why you're at the end of the line too, because I'm looking at it. You know, I know Mr. I know Mr. Jarrett is a lawyer, so I know he wasn't just a guy that had chimed in today. So I'm looking, I say this file is going to come up sooner or later. And of course, the last one I dealt with was like that thick, so I figured that was Mr. Jarrett's file. I figured the biggest one was Rob.
Is that your way of saying, Judge, I don't know how to be concise?
That's my way of remembering the fact that you are a litigator for many years, and when you litigate, it's very difficult for the file to be just a little jacket, you know. All right,
Your Honor.
Yeah, go ahead, Mr. Hibbs.
May I give you the case number for the underlying?
Yes, sir.
It's 20-3501-00LT, and that was Diane Frazier v. Larry Davenport.
Okay, so that's a landlord tenant matter, huh?
That's correct, Your Honor.
All right.
And this is
they should not even cross over, but we'll figure out what's going on there. All right, gotcha. All right, so I will try. Go ahead, sir. Go ahead, Ms. Harris.
May I give you a brief synopsis of this case to bring you up to speed as to what the case is about? Right, and I think it may.
Well, lawyers say brief. I get really nervous, but I'm a lawyer too, so okay.
I think it may give us some guidance in terms of how to proceed. But basically, this is a breach of contract quantum Merowitz suit brought by Paul Curtis, who represented my client at trial in the underlying landlord-tenant proceedings. He's suing for $8,500, but I have receipts from my client showing he paid $2,500. So I would ask Mr. Jarrett to look into that and amend the complaint if appropriate. And I can provide him with those receipts, which are signed by his client. Basically, our position in this matter in defending Mr. Davenport is that Mr. Curtis basically was incompetent in his representation of Mr. Davenport at trial. He failed to subpoena a critical witness, failed to effectively examine and cross-examine witnesses, stipulated on the record that the estate paid taxes when my office was able to obtain receipts that evidence that Mr. Davenport paid the taxes, failed to introduce receipt for a boiler in the amount of $4,542.21, which my client paid for, and failed to emphasize the $10,000 down payment that my client claims he made on the land contract. Basically, if anything, Mr. Davenport's been injured by Mr. Curtis's representation. He lost at trial, and he's continuing to incur expenses in my office because we filed a motion for a new trial, which was denied. We filed an appeal to the circuit court, which was denied. And we filed an application, and this is the important point here, Judge, is we filed an application for leave to appeal with the Court of Appeals. There's a statute of frauds issue on the land contract in the underlying case. And the Court of Appeals on October 5th, 2022, granted leave to appeal. And I think the outcome of that appeal will have bearing not only on the breach of contract claim, but the quantum merit claim for the reasonable value of services rendered. If the Court of Appeals reverses and my client ends up winning the underlying action after appeal at the end of the day, I think that has significant bearing not only in my ability to potentially negotiate a settlement with Mr. Curtis, but also on the evidence to be introduced in the trial of this matter. So what I'd like to ask the court to do is grant a stay of proceedings pending the outcome of the appeal, because I think that has a significant bearing on the outcome of this case, one way or the other.
Well, I get you as far as the some of the evidentiary items that might be admissible here, but of course in the operations that we're involved in, winning or losing is not the issue that determines whether or not you're entitled to a fee. Let me hear from you, Mr. Jarrett.
Well, Judge, you kind of beat me to the punch. I don't believe that the defense to a breach of contract claim for unpaid attorney's fees can be defended on the basis that the client believes that the lawyer could have done a better job. So I don't think that that's a proper defense. I'm somewhat caught off guard with respect to the request for a stay. I had not anticipated that in any respect, and I certainly don't have my client's authority to agree to it. So I suppose I would have to oppose that, at least for the time being. To the extent, although I don't agree that the outcome of the appeal will impact this case, to the extent that I could be wrong on that, I would ask that if Mr. Harris could provide me with a copy of the application, so that if I'm to discuss this matter with my client, I can do so fully apprised of everything that the defense may offer in opposition to the complaint. I had spoken with, as I indicated to the court earlier, I'd spoken with Mr. Harris. He's been quite cordial and quite helpful, and I appreciate that, counsel. But one of the things the reason that I called him is, I do have his answer to the complaint in affirmative defenses. And from that, I got his name and I called him to ask him whether or not he would stipulate to some discovery. And I believe that some discovery will go a long ways towards, one way or the other, apprising the respective parties as to what their posture might be in terms of settlement negotiations. So while I hear Mr. Harris's statements and argument, and I don't necessarily agree to it, I certainly don't have the authority to agree to it, I would nevertheless request some discovery opportunities. $8,500 is not, a world of money, but it's more than enough to justify, I think, a deposition and perhaps some requests for production of documents and interrogatories.
And what I like the delayed reaction, deposition, interrogatories, question within. In any event, somewhat humorous. I just thought it was interesting the way that played out. Let me ask you, Mr. Harris, as far as the pendency of the appeal, I know the leave was granted. Has the court taken that up yet? Is there any calendar that's been placed on it with the Court of Appeals?
It has not been scheduled for a case call yet. The court just granted leave on October 5th. And basically our brief is due November 30th. The other side will have an opportunity to respond. And then I believe once it's fully briefed, it'll be scheduled for oral argument, but we're not there yet. And I think this case is very straightforward. It's a simple breach of contract, although he doesn't have a written contract. I don't think discovery is appropriate, and I think the expense would outweigh any benefit. My client's paying me hourly to defend this, and I think that a case of this, we take issue with the 8,500. We think 7,500 is due and owing, and I'd be happy to exchange information with Mr. Jarrett. I think we can, as two reasonable attorneys, we can exchange information and, you know, informally, and I don't believe that formal discovery with court reporters and such would be appropriate or necessary.
So the first line, unfortunately, I have another courtroom I got to get to, but it sounds like the first line of dispute is whether this should be 7,500 versus 8,500 because of a $2,500 payment. Is that what you're saying, Mr. Harris?
There's an issue there, yes, Your Honor.
I would certainly look at anything he could provide me that would, you know, cause us to adjust that figure.
All right. And I guess the next thing that I'm looking at is that, well, yeah, let's say it's $8,000. Has there been any overtures or gestures that might suggest that maybe we want to try to bring this together? I mean, obviously, you know, time is expensive, and time involving discovery is that much more expensive.
Well, Judge, I'm sorry.
I've suggested to Mr. Curtis when I spoke with him initially on this case that we should try to resolve it, and I also made that statement to Mr. Jarrett as well. I'm open to discussions in that regard.
Judge, I can confirm that Mr. Harris, when I called and asked for his stipulation with respect to discovery, that he asked that we try to resolve the matter. And I, of course, have no opposition to trying to resolve the matter. However, we didn't speak about any particular figures, number one. And number two, I think that the discovery may be helpful in allowing us to assess our respective positions so that we could discuss discovery. So, discuss settlement. So, you know, which comes first, the cart or the horse? I'm not certain, but I think that, you know, the discovery would be helpful along those lines.
And obviously, one of the things that the court has in mind, of course, is the change in the various discovery rules and consideration of proportionality and what should or should not be allowed in light of the relative value of the case and things along those lines. And I know it's kind of difficult to beat out what amount of discovery might be pertinent when you have two lawyers whose time is valuable, and then in addition to that, the reduction of various discovery items associated with that. So when I think about some of the rules of proportionality, you know, it makes it kind of difficult here because this is about a quantum merit or contractual recovery for services performed, even though there's some disagreement about the quality of service. It just seems like this is one that's begging for some real sit down with an attempt to get this resolved. Here's what I'm going to do in short of that, because I think that the two of you have demonstrated that you could probably work through some stuff on your own, certainly without a whole lot of direction from the court. So I'm going to set it on a discovery pathway. I'll grant discovery formally through the 11th of January, and so you can do reasonable discovery during that period of time with the laws of with the rules of proportionality in mind, and I'll set the hearing, the next action date for the 11th of January, 1/11/22, and that's going to be at 10 o'clock a.m. And I'll take a look at where things are. Go ahead, sir.
Judge, if I may, I would like the court to extend the time past the 11th of January for a couple of reasons. Number one personal to me, between now and the holidays, and by holidays, I'm incorporating Thanksgiving as well as Christmas and New Year. I have just, well, let me back up. I had back surgery in the summer, and I had to have stays of proceedings entered into almost all of my cases. those stays are now being lifted almost simultaneously. So I'm just overwhelmed with things that I have to do yet this year. So as a practical matter, even if the court gave us discovery till the 11th of January, I am doubtful that I would have the opportunity to really engage in it in any meaningful way. And in addition to my personal plea for additional time, I would ask that I've asked the counsel provide me with a copy of his application for leave to appeal. And he's indicated that he's got a brief due in fairly short order. I don't remember the date that he said, but with those documents, I'll be able to have more of an understanding. I'm late to the party. I've just been involved in the last couple of weeks. And so if I have those documents, can read them, have a discussion with Mr. Curtis, that may go a long ways towards me saying, okay, we're not going to go into discovery. Let's just see what we can negotiate. So I'd like more time so that I can, A, get my nose above water from my medical issues, and B, have an opportunity to get as much information before I notice depositions and take time and spend money as I possibly can by being able to assess from what I can the application for leave as well as the brief that counsel is about to file. So I don't know how Mr. Harris feels about that, but I'd be grateful if the court would give us more time so that those things can be done first.
I'd be happy to send you the application and the order granting leave. I have a deadline that I have a filing deadline that has to be taken care of today, but I should be able to get that to you tomorrow.
That's fine.
So I'll go ahead and send it over. I'll send it in February, 2/9/23, 9:30 a.m. And because I got attorneys in here that know what they're doing. I mean, the reason I was setting it earlier is because this is not like hardcore. If you at this point, some lawyers have to pull it that way. It's not like hardcore. You already been talking. There's some stuff that you want to do, and you do what you want. You do what you're trying to do, and if you figure out there's something else, then you could, when you come back to court, you tell me the judge there's something else that we need to do, and usually I'll have some flexibility in that regard, as long as the lawyers have been moving forward to try and get at what it is that they need to get at. But I'll go ahead and set it over for 2/9/23 at 9:30 a.m.
Thank you.
And you'll get a scheduling order from me. That scheduling order will also have my famous paragraph number 6 that allows you to file motions, dispositive and non-dispositive motions, and set them for hearing on that same date, as long as you give at least 10 days notice to the opposing party. That can be motions regarding discovery. It could be a motion for summary disposition, a motion to dismiss, or whatever. And the time is short by court order, that all you need to do is give 10 days notice to the opposing party, and I will in fact hear the motion on the date of February the 9th of 2023. That does not forestall your right to file motions in the future, but just if there's something that comes up that you believe is so crystal clear that it should come in front of me, then that gives you the opportunity to do so. And that'll be set forth in paragraphs number 6 of the order that you'll receive from me, the scheduling order that you'll receive in the next few days. Right, so Mr. Jarrett, if you could get if you get your appearance, someone to email that over. I'm just concerned because I want to make sure that as I send this order out, which it'll be prepared today, that we're sending them to the addresses that you all will get the proper notice right away. The court date in the schedule.
Judge, could I please make certain I have the email address correct? You have it at carmen.banks@36districtcourt.org, but I heard something about GH. I wasn't clear on that.
Now that's 36. I was just saying 36 TH. 36.
Oh, TH. Okay, I got you. Very good. Okay, thank you.
All right.
Thank you, Judge.
And we'll get that out to you. You should receive that, depending on the mail, that order before the week is out or early next week.
Very good. And with me sending the appearance to you by email, should I separately file something with the clerk's office, or will that suffice?
That will suffice. We'll make sure it gets taken care of in the clerk's office.
All right, thank you very much, Judge.
All right, thank you. Thank you.
Your Honor, I'll have my secretary email your clerk the copy of the answer and affirmative defenses we filed as well.
Sounds good. All right. All right. I'm gonna track the file anyway, because I simply did not have a file today. It may already be in the file. I just can't tell you that now because I don't have it. All right. Well, let me look at something. Hold on 1 second here. Yeah, the Register of Action does not diary those items that might have been filed. So I couldn't tell you. You could email them or send them to the court or whatever. I'm on it now and make sure we get things taken care of.
Judge, my appearance should suffice to notify the court as to my representation of Mr. Curtis and me being an attorney of record. But I should also mention, if I haven't already, that Frank Jackson is not an attorney of record on this case. And I think a notice was sent to his office. So nothing more should be sent to him on this case.
Yeah, and that's the part that I'm trying to work out, that the Meisner's office and Mr. Jarrett's office should be the persons receiving notice. And that's what I'm going to track to make sure that gets taken.
Okay, thank you very much, Judge.
All right, thank you, gentlemen. Good day to you.
Thank you for your time, Your Honor.
Yes, indeed. On the portfolio recovery versus Sims, no one appeared on that matter. That's the suffix 1441. Looks like that was before the court. Well, I have no idea why it was here, because it looks like there's already an order in place regarding that matter.
I don't see that on the docket, Judge, but okay.
Yeah, I don't think I see it on there. Let me see.
No portfolio cases.
Yeah, I don't know why that's here. Okay, all right, we're good enough. What was the other one? Oh, that's,
I think it was portfolio versus Cruz.
yeah, portfolio versus Cruz. That's the suffix 1381. And nobody appeared on that one. Looks like that was for a motion. Well, I don't see it scheduled.
Yeah, none of them. No portfolio cases.
There's a motion for summary disposition attached, but it's not scheduled on today's date. Sure. All right, very well. We'll try to figure that out. Yeah. All right, thank you.